Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Ericka Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. I'm joined today by shareholder Christina Kuta, who's also part of our healthcare practice. And we're going to be talking about an issue that is occurring nationwide and is impacting a lot of practices. And this has to do with ICE and the various immigration issues that are ongoing. Christina and I have received some inquiries from practices about what they should be doing should ICE show up on their door. Not necessarily interested in talking to their employees, but trying to question or get access to patients. And I know that there are a lot of hospitals out there that have policies on this, but what we're really talking about today is how practices should be dealing with this. And we've put together a policy that we've provided to our practices on this topic as well. We thought it would be really helpful since this is such a current issue, and it's definitely a question that we're getting asked a lot. All right, so we know ICE is out there. It wants to find people that they believe are here illegally. And what we're seeing online is that they're often approaching businesses and either trying to catch people going in and out of businesses or even raiding businesses. So the question we're really talking about today is what happens if you have a practice, whether it's dental, medical, etc., and they show up at your door, ICE shows up at your door, and they want to come in, they want to see who's in the office, and maybe this includes employees, but maybe this also includes patients. So what is the advice that you would give to practices facing this?
So one of the first things I would say to practices, make sure you have a policy. Make sure your employees know sort of what to do and what the outline is if ICE actually does walk into your practice. Don't wait until it happens and then no one really knows what they're doing or how to respond. So have a policy, something in writing that key employees, front desk employees, office managers, etc., are aware of and know how to access it quickly. And make sure it is reviewed by legal counsel. There are certain things that you can and cannot do that could get the practice themselves in trouble, so you want to make sure counsel's reviewed it. But some of the outlines for those policies include asking ICE for identification, getting names, getting badge numbers. You want to ask why they're there. You want to ask if they have a warrant or do they have an administrative subpoena. If they do, you want to make sure you have legal counsel or somebody very knowledgeable about these legal documents review if it's a valid warrant, review if it's a valid subpoena, and what the scope is of those documents. Other things you want to do is make sure they maintain their status only in public areas. You are not required to allow them, unless they have some sort of warrant to search the premises, to actually go to private areas. So back rooms where you have patients in different rooms, or employee-only areas, those are not considered public areas of the practice. So ICE is not allowed to go to those areas. So you want to make sure you're sort of minimizing, where they're going. Also understanding that there's no obligation for a practice to report an immigration status of any of its patients to an ICE agent. There are currently 2 states of which we're aware, Texas and Florida, that do ask patients immigration questions based on state laws. We are not aware of any other states that do that, but there is no requirement in any state that you provide any of that information voluntarily to an authority.
Right. And I can't remember ever being asked my immigration status at a doctor's office on an intake form. So that's certainly something that even if a practice wanted to provide it, they couldn't. Right. I guess, these are all excellent steps. My fear is, of course, that, ICE, based on what we're seeing, will kind of come in and not be willing to talk to anyone, not be willing to show ID, not be willing to, provide any identification. And obviously, the person in charge of the practice, whether that's the manager or the owner, may or may not be present when that occurs. So while we want to have a policy, we want to make sure that you're meeting with your staff and talking through them about the various scenarios that would occur. We certainly don't want to put any staff in harm's way, physically or otherwise, but having them at least state the rules and letting ICE know that they're aware of the rules is important. So there's no perfect solution. We don't know exactly how things will go down, but I assume that ICE will want to, not waste too much time with a practice that knows the rules and is insisting on, ID or other information before they allow access. You'd agree?
Sure. Yeah, I do. And I think it's also important. You mentioned that the practice owner may not be inside, or maybe the office manager isn't always there. You want to make sure to designate in a policy an authorized or a delegated person, and then sort of a backup person who will be the ones to sort of directly interface with the agents and sort of is aware of where the policy is and will kind of manage the interaction. So if that's the office manager and if it's like the assistant office manager, because either one or the other is always going to be on site, that's a good plan as well. But you want to make sure that there's always a designated person who's there and can be responsible for the interaction. Another thing is make sure you take great documentation, whether they will give you identification, whether the agent will give a name or give a badge number or anything like that. You want to document that. What did you get from them? What did you ask? What did they tell you? So you later on can kind of review the interaction. Your legal counsel may want to review it with you, but you sort of have a record of what occurred. And it's always great to maybe have a second witness. So maybe a front desk staff or somebody who can kind of work with the designated person to sort of take the notes or be a witness to what occurred when they had that interaction.
Right. Now, what if they try to take items with them from the practice? And obviously, practices have, protected health information. So, what is our recommendation on that point?
So bring up a great point. So HIPAA still controls. There's no HIPAA waiver for ICE agents. So all HIPAA protected information that a practice would be protecting and would be treating as PHI under HIPAA still needs to be treated that way. There are some exceptions under HIPAA if there's warrants, a valid warrant, or if there's a valid subpoena issued by a judge to gather medical records. That's a different situation. Those would be potential exceptions to HIPAA, regardless if an ICE agent was bringing it in or somebody else was bringing it in. If they provide you with something that looks like they're requesting records or looks like they're requesting to take or review information that otherwise would be considered PHI under HIPAA, you want to make sure to consult legal counsel right away. I would just tell the agent, thank you for providing this. I'm going to take a copy of it. I'm going to consult with my legal counsel to make sure this is valid. Because unless you have particular skill or experience with understanding the subtleties of valid subpoenas for HIPAA purposes and not valid subpoenas and valid search warrants, you want to make sure you have somebody available with that expertise to guide you.
Right. And I guess it's important to note that it's not only printed information. So if you're asked for a patient's name, that's PHI. So even if you're giving it verbally, you can't do that either, correct?
Correct. Absolutely. And patients are free, if they're in the waiting room, let's say, to identify themselves to ICE agents, but they also have the ability to be able to remain silent. So they're not generally cannot be compelled to speak. And certainly as a practice, I wouldn't recommend that you tell patients they should give their names or get involved in that way. That's up to the patient. But the practice itself shouldn't be giving a patient list, shouldn't be letting the agent see the check-in list that's on the front desk that's got the names on it. That's all HIPAA protected information, and that needs to remain HIPAA protected for these purposes.
Okay, perfect. All right. So one last thing I want to mention, because certainly this is a developing area, we're coming out with just guidelines that are kind of best practices as we start to see, how practices are being addressed or targeted by agents. We can certainly update this. But one thing I want to mention is that if you have employees in your practice who work there, who do not have legal documentation to be able to work. That is obviously something different than people who are in your office as patients. And really what we're talking about here are patients. Clearly, you want to make sure that everybody who's employed for you has completed and presented the appropriate paperwork to be able to work in the country, and that is a different topic. But if you also have questions about the people that are working in your office and if they should be working there, or what happens if ICE comes in and they should not have been working there, then certainly please feel free to reach out to us with those kinds of questions as well. But really, what we're focusing here are patients being targeted. All right. Anything else you want to add?
Other than the fact that I think there are certain things that I think practices want to manage on their own, and they may not want to involve legal counsel, and I understand that desire. But this area touches on a lot of different legal areas. There's civil rights law, there's criminal law, there's potentially employment law for employees that are witnessing things or are being approached by ICE, even if it's related just to the patients, like you said. There's healthcare laws. So this is a pretty complex area, and there's a lot of nuances. So this is the kind of thing that you really do want to bring in knowledgeable counsel to help you prepare a policy and to help make sure that you're responding appropriately and not in a way that's going to cause any issues down the road for the practice.
All right, excellent. Well, thank you, Christina, as always. And this has been the Health Law Hotspot. If you have any questions about this topic or any other, feel free to reach out to me or Christina. And you can also catch our other topics at ralaw.com. Again, this is the Health Law Hotspot, and we'll see you next time.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.